I'm Isaac Shutt. I'm an estate planning and probate attorney. I'm licensed in Texas and in Wyoming, and I only do one kind of law. That's estate planning and probate. I feel like that makes me really qualified to answer questions about estate planning and probate law in Texas. I like to say that my knowledge is really deep, not so wide. You know what's interesting? In all of the thousands of trusts I've seen, I see this one mistake more often than any other mistake. And we're going to talk about that mistake in today's video. So without further ado, here it is. Fund it! You have a trust, but you didn't put anything in it. A trust is nothing more than ink on a page. When you create a trust with your estate planning lawyer, it is just a beautiful binder. It is just letters and words on a page. It doesn't have any power to pull in your assets. So if you actually want your trust to do anything, you've got to fund it. And I can't tell you how many times after somebody's passed away, the poor family comes in and says, gee, Grandma paid $10,000 to some outfit out of Chicago. She's got this beautiful gold embossed binder, and boy, it's just padded, it's gorgeous. But you know what? It's just a $10,000 fancy binder. It does nothing if Grandma didn't fund it. So, fund it is just legalese for putting stuff in. That's just what we call it in lawyer terms. Funding your trust means put assets in there. Now, at our law office, we're a little unique. We like to fund our trust in a really easy way because one of our principles is less is more. So there's a really easy way to fund your trust. For one, if you own real estate, just have your attorney prepare deeds and sign those deeds, conveying your assets into your revocable trust. And again, your attorney can talk to you about the pros and cons of your particular situation. Sometimes you might want a special type of deed. Talk to your attorney about that. But the way real estate gets funded into your trust is with a deed. With everything else, and I'm mostly talking about accounts and things like that, just use a beneficiary designation. It's so darn easy. When I did mine with Vanguard, it took maybe 30 seconds to fill out the beneficiary. So basically all I did was put my wife as the primary beneficiary, and then I put my trust as the alternate beneficiary. So what that means is if both my wife and I are deceased, automatically, with no extra hassle for my family, that trust automatically will be funded at my death. It couldn't be easier. It took 30 seconds, but you know what? That's way ahead of the curve because a lot of other people didn't even take that 30 seconds to fund their trust. And if you don't do this one thing, then your trust is worthless. Again, I'm Isaac Shutt. I'm an estate planning attorney based in the Dallas area, and I'm licensed in Texas and in Wyoming, and all I do is estate planning and probate law. We're having a lot of fun making these videos, so more are to come. So subscribe, check out our future videos, and also see the details below on how to get in touch with me or another member of my firm. We'd love to hear from you.